There's people out there who say that you should never take a deal, never take a deal. And if you're never taking a deal, that inherently means that, you should take everything to trial. That doesn't make sense. That is an uneducated, and I don't mean that disrespectfully. It's just, that's not a lawyer's opinion. I don't know any criminal defense attorney who would ever say you should never take a deal, even ones who really love trying cases. I love going to trial, but that would never be my advice to somebody. To some people, taking a deal is the best thing that they can do for themselves, for their families. I think a lot of times that advice comes from an uneducated, anecdotal opinion that's based on their own, their experience, a bad situation that they had where they took a raw deal. A lot of times what happens is the attorney did not explain to them, walking through the evidence, going through any legal issues, any legal defenses. If that process doesn't happen, then the person may not understand why they should take a deal, why it's in their best interest to take a deal, right? Because the reality is there are people who actually did what it is that they're alleged to have done. Recently, I had a case where my client had pulled a gun on the alleged victim, and it was on video and there was audio. There was no refuting that this actually took place. So to advise that person to go to trial would be foolish. At the end of the day, you play that video and it fulfills all the elements of that particular crime. So in that case, we were negotiating the best possible deal for our client. And we went through that same thing. We collected positive letters of support. We collected positive information regarding education history, regarding work history. We sat down with our client to figure out, how did we get here? How did we get to this position? How did this happen? And there was contextual information provided, because again, that can help too. It can be really helpful for a prosecutor to understand why our client did what they're alleged to have done in that situation. It may not rise to the level of a legal justification, but it may be enough to put it into context for them to understand, especially if it was an isolated incident. So this was a one-off thing, an anomaly. This is never going to happen again. And especially if you can put things in place to show why it will never happen again. If they had a lapse in judgment because they drink alcohol and now they're in AA classes, they've pledged to stop drinking. If drugs were involved and now he's in rehab, he's pledged to stop taking drugs. If there were some anger management issues and he's taking anger management classes, doing therapy, these are the types of things, because at the end of the day, the judge and the DA is going to be concerned with, if this happened, how do we ensure that the public is going to be safe, or that the alleged victim or another couple or whomever, how do we ensure that this isn't going to happen again? And so the defense attorney working with the client is going to get all this information together in order to show the client's progress and demonstrate that this is not going to happen again.